I move that we come out of executive session and enter open session. Support.
Any discussion? Roll call.
Susan Prime.
Here.
Barbara Russell. No.
Yes.
Susan Prime. Your vote.
Yes.
Okay. Christina Schnepp.
Yes.
Christopher Schwartz. Yes. Mary Ann Bird.
Yes.
Janine Coughlin.
Yes.
Lisa Hall.
Yes.
We are now in open session for disciplinary hearing for student C at the request of the parent, and we'll have Attorney Gary Campbell start with some opening comments.
We're in open session for student
B.
C.
Oh, I'm sorry.
B.
We were in open session for, at this point, for student B. We're not ready for.
Oh, okay.
For student C.
Oh, okay. We're in open session.
Correct.
Okay, this is an open hearing at the request of the parent. We're now beginning the public hearing requested by a parent of student C. And this is a continuation of that hearing. First off, I want to again remind everyone that pursuant to the Open Meetings Act and FERPA, federal and state laws, we are prohibited from mentioning the names of any of the students who were involved in this particular transaction. And so during the course of this hearing, I remind everyone that we are to refer to the students as student A, student B, and student C, and not to mention the names of the students.
Is student C here?
Yes, student C is here.
Can I address her by her name?
I guess we would, I would say that I would say with the permission of her parent.
Okay.
And I guess that, sir, Mr. Brown, would you permit?
No.
Okay. So he's not permitted then, so he'll be referred, should be referred to as student C.
Okay.
And if at any time, you know, this rule is broken because of the seriousness of this, that we'd have to stop the open hearing at that point and make a determination whether we would continue in closed session. But at the request of the parent, but this is a very serious situation because it does involve complying with federal and state law. And so the proceeding again today will be, first off, we'll have Mrs. Dudley giving a opening statement regarding what the recommendations were by the superintendent's committee recommendation and the basis for that. And then when that's completed, the parent, I think Mr. Brown said he would wish then to speak on behalf of student C. And then after that, then the board would have the opportunity to ask any questions of the administration of Mr. Brown and regarding this. So just first off, and I'll ask Ms. Dudley to come forward to give the administration's position.
On 4/16, bus 0527, we had a report of 2 transportation from an anonymous parent that there was a marijuana smell on the bus, and students were selling both marijuana and pills. After reviewing the bus film, we questioned 5 students, and had each of them write statements. From our investigation, we uncovered that a student the student had brought marijuana on the bus and had sold it to another student for $10. However, we have another student that was involved in the transaction, student C, had taken the marijuana from the student who was selling it, knowing that another student was going to buy it and gave it to the student who was going to purchase it. While student C was in possession of the marijuana, she smelt it and was in clear possession of it during the transaction.
No.
There's not much room there, so, no, that's fine. Yeah. clarify who is all here today?
Per the Open Meetings Act, they do not have to identify themselves to be at this meeting. So they don't have to identify themselves.
Okay, they did not sign in for the,
They don't have to, according to the Open Meetings Act. Would you like me to read you the statute?
no, that's fine.
Okay, thank you.
So, Mr. Brown, you wish to make a presentation?
Okay. I would like to address the board. Thank you for having me today. I'd like to thank all the guests who are here. I would like to ask, because I don't know who the board members are when you speak, because this is a public forum, I wish that you address, or excuse me, state your name so that I know and everyone else knows who's speaking.
Sir, we comply to with our own rules, and we will follow those rules and not whatever you determine those rules are.
Okay, well, can you state your name, please?
You're not here to ask questions,
Well,
you're here to give a presentation.
Well,
sir.
okay, let me get this, okay. Per suspension, more than 10 days, the Board of Education, a school administrator, or disciplinary panel may conduct the hearing as long as they are truly impartial. Now, again, I'm asking you to identify yourself because I received a statement from you as you are a representative of a law firm that has an affiliation with this school board who are present today, Heritage High School and/or the Saginaw Community School District. Now, can you please state your name and let me know if you are affiliated to any of these entities that I just mentioned?
Sir, again, this is out of order. This is an appeal. You can get your presentation.
Sir.
I'm the school district attorney, and so I'm charged with running this meeting, so go for it.
Well,
Present your
according to
presentation.
Michigan Department of Education, my daughter has the right to have a truly impartial party, which you clearly are not, because you just stated that you are counsel for these people. So you are giving
Sir, he
them.
doesn't have a vote in this matter.
Okay.
You are out of order.
Okay.
Give your presentation.
Okay.
Please.
So you're I'm just to make the record straight, you're denying my daughter the right to have an impartial party conduct this according to suspension and expulsion, Michigan Department of Education. Okay. So I'll state that.
Let me just, if I could, please, with
Yes,
all due
ma'am.
respect, I don't believe he's denying that. He doesn't have a part in making this decision. He is here to basically give opening comments about how the process will take place and to make sure it is followed in that
Okay.
fashion.
I respect that, but again, he conducted the first meeting. The Board of Education, the committee, and everyone else had access to him as to my statements and the legalities thereof. So at that time, he could have gave counsel or legal advice to the board regarding this matter of student C. So can you honestly say that you did not give any legal advice since the first hearing until today? Because that will show that you're partial.
Sir, you're just not, this is not the place to be asking questions.
Okay.
I am the legal counsel for the school district, period.
Thank you. That's what I wanted to know. Okay. So let's go into the wrongful suspension of greater than 10 days. Now, Tony sent me on April 16th a statement stating that my daughter, student C, has been suspended on April 17th. And she has a superintendent level hearing. Okay. Now, this document that I received on May 6th, it kind of it outlines, let me find it. Okay. Enclosed for your review are the board disciplinary hearing procedures, 1 page. Board Policy 8350, Student Suspension and Expulsion regarding student due process, 4 pages. Now, on Monday, when we had this hearing, Tony objected and stated, Mr. Brown, you have the wrong policy 8350. So Tony sent me this policy on the 20th, okay? Now, what is so concerning to me, as Tony is the Human Resources Director, he's, correct me if I'm wrong, responsible for the Heritage High School Student Handbook 2013-2014, okay? So according to the original 8350, the superintendent, who is, and I believe it to be Doug Trumbley, am I correct? The superintendent and or administration may suspend a student from 1 to 10 days. Board action must be taken for long-term suspensions more than 10 days. I never received a document stating that my daughter from the superintendent or the board has been suspended for longer than 10 days. Now, Tony sent me this revised version. Now let me read the back, which is very important. The original one states, approved December 12th, 2005. Can you please let me and the public know what persons or entity has the authority to approve such a document?
Again, sir, this is not a period of questioning. You
Sir,
made
this
your
is
statement.
very imperative to my stance here, because this document was changed April 28th, 2014 during a pending investigation, which concerns me greatly. So this is the time for that question to be answered.
It is not. You can give your statements, give your argument.
Okay,
That is what
my
you're-
argument is, I received the initial document, which is part of your proof, which is what the Board of Education is basing 100% of their decision on. The Board of Education, I witnessed on Monday, expel 2 students without reviewing all of the evidence and or suspect proof. I witnessed because the board said, hey, after student A and student B were expelled, when it came to student C, oh, we didn't see the video. Let's have a closed session and view the video. So that tells me that you are making decisions strictly based on a document that is not factual. Okay? So the Board of Education is putting the lives of students in their hands based on a committee who is doing improper investigations. They don't have a protocol. It states that they are to report to the police, a level 4 offense. I asked Tony several times, do we have a police report? On Monday, he said, yes, he spoke to the police. He said he couldn't do anything because there was no physical evidence. No physical evidence. So the police can't do you have that report for us, Tony? Or was that also hearsay?
Just make your argument.
Okay, so again, we don't have any proof of Tony reporting this to the police. I don't have any statements. I should have all the evidence. I requested all the evidence several times. I don't have that statement. Tony emailed me, and I have this document as well, the revision of 8350, which still doesn't coincide with Heritage High School Student Handbook 2013-2014, which on page 22, or it may be 23, because Tony said when you print it out, the pages go to the next page. It states that the same thing that I just read. After 10 days, the superintendent or his assigned persons are the ones who are authorized to suspend more than 15 days. Mr. Trumbley, where are you? I never received that. Do you have that document? No. There is no, so there's wrongful suspension here. This is part of their statement. May I please approach them so they can see and pass around the statement?
I'll take that and pass it about.
Please note, my daughter stated that Mrs. Dudley asked her, threatened her that she has to write a statement. My daughter didn't know what Mrs. Dudley was talking about when she asked her about the incident. In your report, it said she didn't know. She said such and such. Ms. Dudley said, no, if you don't tell us, you're going to be in trouble for insubordination. So, therefore, she wrote the first line. As you can see, if I had the original, I could tell it's two different colors. I deal in contracts all the time. Blue shows up perfect. When you photocopy black, it's lighter. So, here you go, sir. Can you pass this around and please show them that both of these handwritings are different, showing that my daughter wrote those statements at two different times because Mrs. Cole came and got her out of class after she initially wrote the first statement and told her, that you have to write another statement. The ISS teacher and Mr. Primo said it was not right, and she must add that it was weed and pills in the bottle. So he is coercing, whatever you want to call it, my daughter as to what she has to write on this statement. Okay? So all students were in the ISS room. Ms. Dudley told them they couldn't talk to each other. Mr. Primo told them that if they gave a sincere apology and be honest, everything will be okay. So these are promises made by the staff, and my daughter wrote this statement under duress. She can't leave. They have her confined. A parent has to come get her. She can't leave. So they are forcing her to write these statements in which you are trying to expel her on, and you have no physical evidence. That's why we don't have a police report, which is required. Also, it says, definition of the types of incidents requiring reporting to the law enforcement and response by law enforcement, taking into account the intent of the actor. Now, if you've seen the film, which I know all of you have it, if you see the film, you can't identify what's in their hand. You can't say that that's what that is or that's what this is. The intent of the actor, my daughter, yeah, she was in there. It looks suspicious, but we don't know what it was. All we know is these students were forced to write a statement. And from that statement alone, they're being expelled. Okay? Initial response by the law enforcement agency, which shall be specifically tailored for incidents in progress, incidents not in progress, and incidents involving delayed reporting. School officials shall be consulted to determine the extent of law enforcement involvement. I guess because Tony spoke with the guy and he said he couldn't do nothing, Tony doesn't need a physical paper report to hand to anybody stating and proving the day and time that he spoke with this said officer. This provision shall require, that's cool, okay. Damn. Yeah, because I don't find any of that in the correspondence that I was given. Yeah, and again, building level administrators may suspend students for up to 10 days. A committee of certified employees may suspend students for up to 10 days or make a recommendation for longer removal from school. The superintendent may suspend the students for up to 25 days. Again, Superintendent Trumley, I never received any documents, any requests, anything stating my daughter was suspended for more than 25 days, for more than 10 days. Today is the 25th day, including the Good Friday and the one day that you had for in-house, okay? The Board of Education must approve suspensions greater than 25 days or longer from the school. So one, the superintendent, there's no such request. So this is showing that my daughter has been suspended illegally And I'm gonna go to something else for you. Now, in this student handbook, you know, everywhere in the student handbook, I see student rights and student responsibilities. Everywhere except a level 4. That's funny to me. The most serious offenses, you don't have a due process for. Now, the goals, and it's funny because it's not required yet, the goals for Michigan's zero tolerance law. Due process. Now, in the handbook in which Tony writes, or is one of the major authors, he does have the bottom 4. Usually you place the ones that are important at the top, so the first 3 he decided to leave out. You know why? Because it's easier to expel students if they don't know their rights. It's easier to expel the students if the parents don't know their rights. Now let me read you the top 3 recommendations. Provide substantial due process rights. Notice, hearing, right to attorney. Did any of these students have that? No. Why? Because it's not in the handbook. Secondly, provide advance notice whether law enforcement referral will be made. No. Allow students, now this is very important because this is why we are here today. Allow student to speak with parents before being questioned by the school. These are the top 3, so if you eliminate those, it's easy to convict. And then Tony is steering, when we were in the initial meeting, Tony kept saying, nowhere in the history have we ever had an open public hearing for disciplinary action. He kept telling me that. Why does he keep telling me? Well, I'm going to do the opposite of what you suggest. Even in the document, he's steering parents, and let me read it to you verbatim. He's steering parents to have a closed meeting. Okay. One second, please. Thank you for your patience. That's 33, so I'm looking on page 2. Okay. You asked to have a hearing before the Board of Education. The hearing can be closed to the public at your request. You know, at our meeting on May 5th, 2014, you asked that the hearing be open to the public. If you change your mind about having it as an open meeting or having a hearing at all, please call Mrs. Dorr. That's like steering a parent, hey, don't have an open meeting, have a closed one. So that's probably why in all the history of Heritage High School and or this Board of Education, there's been all closed meetings because you're steering people to have the wrong one so you can do whatever in private and convict these kids and kick them out because they don't have any rights. They don't know their responsibilities. Neither does the parents. And then, you know, excuse me one second. And the board knows that I live in Westland, Michigan, but whoever scheduled this schedules this at 7 a.m. knowing I have an hour and a half drive. That's funny. You know, hopefully I get a flat tire or I don't wake up to be here. Yes, ma'am.
Mr. Brown, you have made a lot of statements that I feel are opinionated because you keep saying that it appears to you that somebody is being steered in one way or another. I'm here as an official board member to hear from the student C and or her representation.
I'm her representation.
Okay, but you've complained about laws and regulations that are approved by the state and have been, and they're the same for every student. That's not what I'm here to hear. I want to hear about your daughter and the situation in this particular case. I had no idea that you lived in Westland, okay? I'm here because I want to hear about this case, about student C and what happened with student C. There has been nobody who is trying to steer how this meeting is supposed to go or end up at all, okay? We do everything that we can to protect the identity of the students, and I assume that that's what you're doing by not allowing me to ask her name or address her by her name. You're just saying, say student C, and I will abide by that. We do whatever we can to protect the identity of all students, and especially when it comes to a hearing such as this. I would like to hear about, from her or from you, her representation, about the facts of the case.
Okay, let me address
Also,
what.
Before you go any further, I advise the board also to please wait until Mr. Brown has completed his presentation, then at that point, we can go into these other things.
Well, may I address her accusation?
Me.
Yes,
Okay.
she
Well,
asked
she
you-
said that I was making a lot of opinionated statements. I only made one, and that was that he's trying to steer people. Tony, I didn't say the board or anyone else, I said Tony because he is the writer of these documents. That's the only thing that I said opinionated. Everything else is documented in these statements, and I'm telling you where I'm getting them from, that it is facts. I'm not opinionated on anything except for I assume that he's steering parents to elect a closed hearing rather than an open hearing. That's the only opinion that I have. Everything else is facts. Now, if you want to go into the facts,
please report to your car and move them. Thank you.
does everyone have a copy of?
We need to break for a second.
The buses can't get in the bus.
Oh,
People are hurt.
Thank you.